All right, we're live. So we're going to wait a couple more minutes to let people get into the room, and then we're going to talk about COVID-19, the impact on the business, and potentially you individually, and how to deal with that impact. So we got about 2 more minutes until we start. Make sure you get your questions in. I will have moderators that go through the different comments and questions to make sure they answer. We're going to do primarily business this time, and if you guys like it and show up, we're going to do individual next week, and we're going to keep this going on a weekly basis. So feel free to email, comment, message any of your questions so that I can answer them shortly. So we got about 2 more minutes, and I see 7 people have logged on already, so that's a good start. So keep logging on. Just please share the video if you can. And we're going to have about 20 minutes, half an hour, that I'll be able to answer all of your questions. Before we get started, I want to thank my team for setting it up. Andrea, Lorraine, Gabriella, Artillis, everybody at Van Horn Law Group. Thank you for your effort in putting this together. This is my first Facebook Live event. Tomorrow will actually be my second that I'm doing with Legal Aid. Shout out to Legal Aid. So I'm really excited. I hope that this is beneficial to everybody. So we got about 35 more seconds, and then we're going to get started. I'll briefly talk about what I'm seeing from my side. Tell you some stories about clients that I'm working with, and then I'm going to answer some questions. Thank you, Andrea. Wish me luck. Hopefully I can keep you guys entertained. Thanks for joining, Mark. Hope all is well with you. All right, it's noon, so let's get started. So the title of this is how to deal with COVID, how your business can deal with COVID. Pretty much every business has been impacted by COVID. Unless you're making masks or working for Purell, you've probably been negatively impacted. Many of my clients, I represent gyms, restaurants, I work with retailers, are really struggling. I mean, sales are down, in some instances, down 100%. So if you have no revenue coming in, and unfortunately you still have bills to pay, whether it be landlord lease, unsecured debts, what do you do? The government has tried to step up and provide different programs like the PPP program, which helped some employers keep their employees on and get a forgivable loan. The economic injury disaster loan, which is a $150,000 loan that gets repaid at favorable terms, which is good. But what if your business literally has been shut down? Like I represent certain gyms that were shut down for a period of time, restaurants that were only set up for takeout, and then got to 50% capacity. I know our friends down in Miami are still not allowed to have indoor seating, so they've transitioned into different areas, like doing more delivery, doing more takeout, coming up with new ideas. So what I encourage all my clients to do is try to, this is your time really to come up with new ideas and try it. I know one client that I'm working with actually had a better July this year than they did the previous year, and they attribute that to doing takeout and delivery for the first time. And they're going to keep that on once we get through this. Hopefully we get through this sooner than later. So if you can come up with ideas to drive more revenue, that's great. The number one issue that I'm seeing with businesses is issues with landlords. I represent a club in Miami. Obviously, all clubs are shut down. Unfortunately, the leases still due, the lease payment's still due, and it's a significant payment. So we're stepping in and we're trying to bring landlords to the table to work with our client. Unfortunately, they were current with their rent for years. They missed 1 month of rent and they get an eviction notice. And they even were making payments while they were shut down, but then unfortunately they ran out of capital. So what I recommend my clients to do is make sure that you're working with your creditors, especially the landlords, because in bankruptcy, we really can't do that much with the landlord. We can't force new terms on them. We can stay current moving forward after we file and then make up the back payments over time. But unfortunately for a lot of my clients, that's not even feasible. So with your business, another thing that I'm telling my clients, try not to freak out, try to stay positive, try to get through this. I mean, we're all dealing with this. I know when I came back from my honeymoon, which was in March. Thank you to everybody at Van Horn Law Group that held it together and we were staying in contact. I had no idea the mental impact that it was taking on so many people. So I mean, do things mentally that will benefit you, whether it's working out, whether it's going for walks. Try not to drink too much wine and alcohol to supplement it, because we don't want to get into those negative habits. Because we are going to get through this, and we're going to get through this as a team, as a community. And if there's anything I can do, I'm still here 6 days a week, and my staff is here to help you out. So even if you had the most basic question, feel free to email me, reach out to set an appointment. We do 15-minute free appointment slots all day. So that being said, we have our first question that's coming in from Scott. How will personal bankruptcy affect me or my business? That's actually a great question. So if you file a personal bankruptcy and you own a business, you have to list the business as an asset or as something that you own. Now, the trustee in your bankruptcy case, whether it's a Chapter 7 or a 13, will have somebody come in and look at a valuation of that business. So if the business had $100,000 in the bank account, no debt, they can actually come and demand turnover of that money. So it becomes a little more complicated when the business has its own debts or if there's multiple owners to the business. What many people don't realize, if you own an LLC and there's multiple members, your ownership interest actually goes to those other members when you file bankruptcy. So it possibly would not be property of the estate. And that's depending on how your membership agreement, shareholders agreements worked out. So there's many different things that come to mind whenever you talk about ownership of a business, because there's so many different types of businesses. So you really want somebody to do an analysis of what is the liquidation value of that business, what's the value as a going concern. If you are the business, if you're a handyman, or if you're a marketing person or some sort of service where the business doesn't really have any assets, you are the asset, it's not really that big of a deal. But if you have a business where you're manufacturing something, then that potentially could be a big issue. So Scott, I hope that answered your question. If you have any follow-up questions, feel free to add them to the chat. Let's see if we have any other questions. And once again, thank you for bearing with me, because this is my first time on Facebook Live. All right. Andrea Artillis. I don't know where to get the good. Oh, here they are. Okay. Oh, I got a question about Subchapter 5 bankruptcy. So Subchapter 5, Chapter 11 bankruptcy is kind of the new kid on the block. It really had nothing to do with COVID. This was passed way prior to the COVID times. It's supposed to make the Chapter 11 process smoother, cheaper, less admin fees. And we confirmed our first Subchapter 5 plan. The admin fees may be a little more, depends on who the Subchapter 5 trustee is and the complexities of the case. The good part about it is you can confirm a plan without the creditors voting, unlike a normal Chapter 11 where it comes down to a vote of the creditors, as long as you're being fair and reasonable and putting that out there. Chapter 11 is great for companies that have too much debt, but they can pay it. They're operating, they have revenue, they have too much debt. They just need a payment plan. There's ways that you can reduce what you owe to creditors as well, secured and unsecured, as I said earlier. Doesn't really do much with landlords or leases. That's more of a negotiation directly with the landlord. So I hope that explains the Subchapter 5. It's coming out different ways. There's different results. So that's something you really want to talk to your attorney if you're going down that way. We got a question from Michael. How can I manage my business lease, which is falling behind while staying open? So again, that's going to come down to a negotiation with the landlord. The Chapter 11 is a good backup if you can stay in there and make it through the initial eviction proceeding or whatnot. The good thing about the evictions right now, commercial evictions, they're not stayed. There's not a moratorium for them, but they got rid of the summary eviction, so you have 30 days to respond. So you actually have more time to stay in the space. but you're going to need to come up with a resolution. So hopefully you can get the revenues up to at least pay the landlord. If you can cut other expenses, including unsecured creditors, I would use that money to go to the landlord. Obviously, if there's a way that you can reduce your space, move into different space, that's a good way to go as well. And then you can file a Chapter 11. If you have something like a restaurant where you need that exact space, that might not work for you. But if you have something else, like a consulting business or something where you can move office space, then the Chapter 11 can make the liabilities go away for the previous lease. So, oh, hey, Cindy. Hey, Tanisha. Thanks for joining, guys. Dale from Davie asks, what is the long-term outlook for these businesses? Tell you, if I knew, that's a tough question because we all know that businesses are struggling. Some businesses were prepared for a couple months of this, 2 to 3 months. We're 6 months into the COVID world. Um, Many businesses, the businesses that survive, I think, will come out stronger. Initially, there'll be less competition because so many businesses are closing. So if you're able to survive, if you're able to get through this, you could come out stronger. Unfortunately, I think that there's going to be a ton of businesses that just close without bankruptcy. You're not really going to hear much about them. You're just going to see vacant spaces, and businesses are going to go away. And you're seeing this with large companies that are filing bankruptcy, um, including the Steinmarts of the world. I saw Neiman Marcus is leaving the Galleria Mall. And with every one of those closures, you're losing jobs as well. So what I see initially, I see a bunch of businesses closing down, and then unfortunately behind that are going to be the employees that don't have the income, and will have too many bills that will end up filing individual bankruptcy. So, oh, thanks for the shout out, OJ. Thanks for joining as well. So I hope that answers the question. That's the long-term outlook for a lot of the businesses. I think they're going to close, and then new businesses will start up. The businesses that survive will be much stronger because there's still consumers out there that need things, and will need the services. There'll just be less businesses in the short term offering those services. So Tanisha, what can individuals do that are facing possible foreclosure and not making the same income prior to COVID-19? So initially, what you would do is go into a forbearance, go into a deferment of your mortgage payment, which many of the mortgage companies are offering. So do that as much as you potentially can. Take advantage of those forbearance programs to survive. And then at the end, what the companies are supposed to be doing is putting those payments on the back. If they do not, then reach out to somebody like me, and then we'll negotiate a loan modification or something like that. The good thing is the banks are in a better position now in that they went through the 2007-8 crisis where they put these loan modification departments together. So they certainly know what to do, and they have procedures in place, and we know what to do. So I hope that answers your question. They're coming in quick. So Jeff, can a debt collector get a judgment on a deficiency balance less than 5,000? What are the debtor's options? I believe do nothing. So the first question is, yes, they can get a judgment for deficiency balance. And I guess that's with regards to foreclosure of some sort of assets, whether it be a real estate or anything else that they have a security interest with, or a UCC1. For example, if a restaurant got a loan with UCC1 and they had a blanket lien, they sell the restaurant equipment, there's something left over, they can get a judgment. The debtor's best option with that, if it's less than $5,000, I'd recommend negotiating and settling. If you have much more debt than that, then you want to start looking into bankruptcy options. But once again, you want to look at whether the business is just liable that's closing, or there's personal guarantees. If there's a personal guarantee, you're going to have to negotiate or do something with that as well. Hope that answers your question. If you have any follow-ups, let me know. Melissa, how long should businesses wait to file for bankruptcy? That's a great question. Timing is huge with bankruptcy. You got to do it at the right time. I recommend not rushing into it. Unfortunately, we have some clients that come in where the foreclosure's happening, the eviction's happening, the bank seizure, all their money is frozen, so you really don't have the timing that you want. What I recommend is getting things lined up first, as much as you can get lined up. So talk to the largest creditors, talk to the landlords, talk to all the stakeholders within the company, and get everything organized prior to filing if you can. I wish all my clients came in, were completely organized, and said, okay, we have a general plan here, but generally speaking, they come in and something happened, they're freaked out, and they want to save their business. And we have to plan immediately and get filed quickly. So the quicker you can get in and understand your Chapter 11 options or your bankruptcy options, the better off you're going to be, and the better off my team is going to be, because it makes it easier for them, because they can go in with an organized plan instead of trying to, as they say, build the airplane while in the air. Great question. Thank you for that, Melissa. So Susan, can a business take out new loans while in Chapter 11? Certainly. So there are mechanisms within Chapter 11 where you can take out new loans. You have to get approval for them. Generally speaking, they're going to want some sort of collateral as well. So if you have assets that you can put up for collateral, those are certainly options. Also, the PPP loan has been determined that you can get that through Chapter 11 bankruptcy. I understand that through the new, I believe it's called HEAL Act, that they're going to make it very clear what you can do through a bankruptcy and what you can't, which that guidance will be appreciated, because we haven't had it over the last couple of months. But there certainly are lenders out there that will make loans to Chapter 11 debtors. What options do individuals with student loan debt may have to resolve their default loans or stop defaulting on their loans? So we're going back and forth from the businesses to the individual. There's tons of options with regards to student loan. Right now, the federal student loans are put in deferment until the end of the year. So you really shouldn't be making any payment. No interest is accruing. You are getting qualified payments listed in your history. So right now, really, there's nothing to do. Just make sure everything is organized, and that's it. And we'll talk more about that when we do a consumer session. This, generally speaking, is more for the local businesses. So let's see. Oh, all right, Miss Lola. After filing for bankruptcy, how soon can you purchase a house? Well, the exact answer for that is there's no restriction for you purchasing a house. You can purchase a house, immediately after you file bankruptcy. But I'm guessing you're asking, how long will you qualify for a loan? So the Federal Housing Authority, an FHA loan, they say 24 months after the date of filing, so 2 years. What we're seeing with our clients are the earliest is about 12 months, 12 to 18 months, and then you're back in the 700 credit scores so that you can get back qualified for that mortgage. Hope that answers the question. Carolina, what steps do I take to dissolve your corporation? So that's a great question as well. So some companies, as I said earlier, are not going to file bankruptcy, and I think the majority of them aren't going to file bankruptcy. So the steps that you want to take are, first, you want to send the statutory notice out to all the creditors that you're closing down the business. Second, you file with the state. You dissolve the company with the state. Third, you file your final tax return with the IRS. And that, generally speaking, will protect you. Make sure after the company is dissolved, do not take out any additional lines of credit, debt, because then they can pierce the corporate veil and come after you individually. You also should know what you're personally responsible for. So check with the landlord to see if there's a personal guarantee or any other creditors as well. How long does bankruptcy stay on your credit report? So bankruptcy is actually not reported on your credit if you file a Chapter 11 for a business. So if you're the owner of the business, you sign the petition, that will not report on your credit, will not impact your credit at all. Going back to the personal guarantees, if you default on those, potentially that will impact your credit. Chapter 7 is on your credit for 10 years. Chapter 13 is on your credit for 7 years. You can rebuild much quicker than that, though, as we discussed earlier. Next up, Regis is filing bankruptcy. How can my company submit construction bids for future work and protect itself from a future reachback? That is a great question. Regis and those type of working spaces, they were the darling for a while, and then they kind of fell off. So with that, you want to make sure if you can get some sort of security interest, especially with the future work, and get paid normally, because what you're trying to do is avoid clawback lawsuits. And if you can get kind of COD for your work, that's going to be your best bet. But just make sure everything is documented, and that when you're taking on future work, you're not falling behind on payments with them. I would go to COD with them, or have a third party guarantor come in and guarantee that work. Um, Robert, how does a bankruptcy impact my relationships with important vendors? Another great question. So, and it leads into that previous question from Tom. Uh, with the critical vendors, you want to get them on board, and many of them will go to COD, which you need to be ready for. With many of my clients, COD is actually not a bad thing because they have so much debt that they're paying towards, bad debt that they're paying towards. They once they get off of that negative financial cycle, it becomes a positive cycle where you're used to having cash in the bank to make these purchase orders. So what I tell all my clients is we're going to reach out to the critical vendors on day one and make a deal with them so that we can continue working with them. In my experience, the vendors will continue to work with you, especially if you've had a good relationship in the past, because they still want your business coming in, and it might be hard for them. I've had vendors write off hundreds of thousands of dollars worth of debt and still work with my client because on a COD basis, they don't have the risk, and they're still bringing in money. So that's what I recommend is reaching out, communicating with them directly, and trying to make a deal early. And thank you everybody for participating. I didn't realize that we'd get this many questions. This is fantastic. Another one from Tom. Hertz is a tenant in a building we own, and the trustee is requesting a rent reduction. Does this allow us to terminate the lease? So the actual request doesn't allow you to terminate the lease. But if they don't follow through with if they default on the lease and they don't follow through with making payments, then you certainly can evict them. And what would happen through the bankruptcy is they have a certain date where they have to assume or reject a lease, and they actually have to remain current on the lease moving forward. So if they're not current on the lease, what you do is you go into the bankruptcy court, you move for relief from stay, and you also have an admin claim for any payments that they haven't made to you post bankruptcy. And then you would have a general unsecured claim. There's a formula in the bankruptcy code to how to calculate rejection damages. So when they reject the lease, you would have an unsecured claim for a certain amount. So Laverne, is it true that Van Horn Law Group is the only firm that assists in credit rebuilding after filing bankruptcy? I don't think we're the only firm. I think that is a unique part to what we do. We realize that when people file bankruptcy, whether it's business, individual, or whatnot, they're not just filing bankruptcy just to say they filed bankruptcy. They have a goal in mind. And many of our clients' goals, they want to get rid of debt, they want to rebuild credit, and they want to just put this behind them. A lot of people talk about the stigma of bankruptcy. I honestly think that's going to be gone completely with COVID, because so many people are filing bankruptcy and they did nothing wrong. They were working in an event planning industry, the cruise industry, the restaurant industry, and everything was great. Season was coming up. They were going to make a ton of money and build up their savings for the summer where it might be a little slower. And then of course everything shut down, and shut down not for a short period of time, unfortunately a long period of time. So don't feel bad about knowing what your options are. This is not a life sentence. This will not be with you for the rest of your life. And if you go through an interview and they pull your credit and you ask what happened, you say, it was 2020 happened. And any employer that holds 2020 against you, I mean, they might have filed bankruptcy, or I'm sure somebody in their life has filed bankruptcy or foreclosure or something like that. Lydia, if I file personal bankruptcy, can I keep one credit card open for travel? That's one of the most common questions I get from the consumer side. Unfortunately, they shut them all down. Even if it was a zero balance, you never defaulted, they're going to completely shut down all your credit cards. The good thing is, approximately 3 to 4 months after we file, in a Chapter 7, you're able to reestablish credit and start rebuilding. Also, you can be put on as an authorized user if you have somebody in your family or a close friend that would let that happen. So, wow, we're already at 25 minutes. That flew by. So we have about 5 minutes left. If there's any other questions, make sure that you ask them. I hope this was helpful to people. Um, you really, if you have detailed questions, make sure that you ask me directly through the phone so we can talk and dig into the details, because I want to make sure that you get the right advice for your exact situation, whether it be your company individually. I'm here to help you guys out. As a community, we're going to get through this together. Oh, we got one more here. Dale, why is there a 2 month delay before the 341 hearing and the final clearance of the debt? What's actually happening during this period, and what happens if a creditor protests? Will it cost more money? So the 2 month delay, generally speaking, is for the trustee to do their report of noted distribution. They have time to look at assets. It's really for the trustee and the creditors to do their due diligence. Uh, if if a creditor protests, there's a couple ways they can move to dismiss the case. They can file what's called an adversary proceeding, which is a separate lawsuit within the bankruptcy to say that their debt should not be dischargeable for some reason. The main reason for that is fraud. So if you committed fraud, that debt, generally speaking, would be non-dischargeable. But there's certainly other categories, and they can also move to revoke your discharge altogether, just saying that you're overall not a good person. Adversary proceedings, generally speaking, are separate retainers. So if there's litigation involved, that's taken care of. If there's just general objections, those are covered by our retainer and probably many other attorneys' retainers as well. So it really depends on what attorney you're working with. We try to include as much as we can in our retainer. Unfortunately, when it comes to a separate lawsuit, it's hard to price that into a retainer because we just don't know when it's coming. We always say that look out for the X's whenever you file bankruptcy. Ex-business partners, ex-spouses, ex-boyfriends, girlfriends, or whatnot. Those people that might have an axe to grind that would file that lawsuit. So, great question. Though. It really is a good question. Phil, thanks for showing up. Thank you, Uncle Tom. Looking forward to seeing you. Thank you, Leanne. Thank you, Tanisha. Thank you, Scott. Um, so I don't think there's any other questions. Once again, thank you for everybody that made this happen. The time flew by. If you have any other questions, feel free to go to Van Horn Law Group to set that up. Give us a call. Like I said, I'm available six days a week. I got a fantastic team behind me. I look forward to working with all you. Thank you for your kind words, Dale. And I guess we're done. Signing off.